Hello, everyone. Thanks for joining. This is Paul Hitchcock with the asset protection estate planning firm BarthCalderon. Really excited to have you on today. We know everyone's really busy, so thank you. And this is an hour-and-a-half workshop, and you're going to get a lot of really incredible information from Harry Barth and Glenn Fuller. Glenn Fuller is an expert real estate attorney. You saw the invitation, you saw his bio. Really well-known speaker across the country, and so there's going to be great takeaways regarding the real estate and other issues. Harry Barth is a nationally recognized speaker on asset protection and estate planning, and the founder of BarthCalderon. So we do about 40 workshops across the country every year on subjects like this. So you're going to hear that same content today. Really excited to have Harry and Glenn present to you. And a couple of maintenance issues here is, one, we have a great complimentary assessment that is offered to all of our attendees at our live events and our workshops. And so as a follow-up to this webinar, you will receive an email which will include not only Harry's ebook, but also the complimentary assessment offer and some other goodies relating to the content here, both for Glenn and Harry. So look for that email after the event. And again, thanks so much for showing up. And now I'm going to have our presenters jump in, and thanks.
Well, good morning, everybody, or good afternoon, depending on where you are. I'm Harry Barth, and thanks for joining us today. I sure hope you can get a lot of takeaways from the information that we're about to provide. So I'm going to spend the first part of our workshop this morning discussing with you asset protection of real property. And so when we talk about asset protection of real property, I think we need to talk about what asset protection is in general first, and when it's used and when it's appropriate and when it's not. Inherently, asset protection, ladies and gentlemen, is the methodology of arranging one's assets in such a way as to allow us to be able to settle a potential claim in a much better position than we could have settled that claim in the absence of that protection. You know, the last 30, 40 years that I've been in practice, I've just seen nothing but a tremendous explosion of lawsuits throughout the United States of America, and mostly the United States of America. I'll give you some interesting statistics which will kind of help set the stage. Last year in the United States of America, there were approximately 50 million lawsuits. And that's just an astonishing number. We have 300 million people and 50 million lawsuits filed. And we need to understand this for a second or two, that every interaction with the judicial system is a lawsuit. So whether it be a tort claim, an environmental claim, a tax claim, an immigration claim, or all claims, divorces, criminal actions, tax actions, are all begin with a complaint and a lawsuit. Also, it's very interesting to note that 95% of all litigation in the world occurs in the United States of America, and only 5% occurs outside the United States of America. Now, interesting. We're a country that has contingency fee lawyers. We're a country where everybody pays their own legal fees rather than the loser pays the winner's legal fees. We're a country that believes in exemplary special and punitive damages. I work in some other countries, and I can assure you that the vast majority of them do not have that level of legal interference, which makes it just so much easier for people to bring about lawsuits in the United States. The other thing I think that's important to understand is that lawsuits and their attendant costs represent close to 3.7% of America's gross domestic product. And that's an astounding and a staggering number. You know, and lawsuits just don't revolve around money. Lawsuits revolve around emotionality, loss of night's sleep, loss of privacy. We've seen such scenarios where even though the lawsuit may have been okay as far as opportunity is concerned, we've seen the emotional toll that takes place with lawsuits. So given that as a backdrop or backstop, let's move a little bit and talk about about some of the, we'll call it some of the 3 rules that have to be put in place before one should engage in asset protection planning, and some understandings of some basic rules and regulations that will help you. First of all, I think a basic rule that's critical in asset protection planning is that we do not do asset protection planning after the fact. I think that that is absolutely critical to understand. So you might laugh and you say, well, you know, we wouldn't do that. But let me help you a little bit. Although we understand that if our homes were on fire and the roof was burning, it would be probably an inappropriate time to give a call to the home insurance people and say, hey, look, we have inadequate property coverage or fire coverage, we need to increase our coverage. Or if we've had, sadly, a serious automobile wreck and we've injured people and we then wind up being sued, it's not really a great time to call the auto insurance people and say, hey, here we go, it's time to increase our automobile insurance. But surprisingly enough, we will receive calls. Remember that stuff that we learned about a little bit from Glenn and Harry on Thursday morning at that webinar? Can we adapt or adopt some of those strategies and procedures to help us? We've had a problem. So, ladies and gentlemen, let's just say and make it very, very clear that asset protection should be engaged in when there are no storm clouds and no problems on the horizon to make them effective. So that's the kind of axiom number 1. We don't do it after the fact. Now, axiom number 2 is very interesting. And it has an impact on real estate and things that we see. People are under a false notion that if assets are held in their living revocable trusts, the trust that they put together for their estate planning, those trusts that they put together to put together the distribution plans for their children, that somehow those assets are protected. So, well, my building is safe because it's in my trust, or my home is safe because it's in my trust. I can assure you, in your basic living revocable trust, that the creditor can reach every single one of your assets. It provides no asset protection whatsoever. And we get an astounded look that comes to us that says, well, then why did I do it? We did it to avoid probate, we did it for privacy, the estate tax. We did it for many, many reasons, but asset protection is definitely not one of them. I don't know where that comes from, but sure as heck is out there. We see it almost every day of the week. And so now the third axiom that we need to talk about is I have insurance for that. So one of the things that we'll hear constantly as well, we bought insurance to cover ourselves for the liabilities rising up from our property or our actions as a member. Well, let me begin by saying that I believe that it's very, very important that we have the appropriate and proper amount of insurance available for each and every one of us. I think it's really important because we can drive a plaintiff to that insurance policy. But the problem that we face is not a know-all, end-all solution. So it always amazes me when we see the following answer. People will buy $1 million or $2 million or $3 million worth of liability insurance. And I guess the assumption is at that point that they will have a liability that's within those policy limits. So it's just always, well, people say, I have $1 million. But there's not a relationship between the amount of insurance that you have and the amount of the judgment that can go against you. So one of our clients said very recently had $10 million worth of liability insurance and was able to $22 million investment fund. So I think it's really important to understand that insurance is a basic tenet, but it's not a know-all, end-all to everything that we do. The other issues that come along, I think, are kind of a bit of the insurance world, not negligent or intentional misrepresentation, but I think sometimes people do not quite understand some of the concepts of insurance in this respect. So you have to well remember that commercial where we had the guy walking down the street, a travel commercial with a big red umbrella, And we kind of feel in many ways that everything that can happen will hit our umbrella coverage and fall off. If that was the case, our policies would be one page long. This happens to be done. Sadly, our policies are 65 pages long, full of covenants, conditions, and restrictions. And if the cause of action that you face as a landlord or as a tenant or as a owner of the property does not fall within the it's called the insurance clauses, you may have no coverage for that whatsoever. Examples are special damages, exemplary damages, punitive damages, damages that are somehow unrelated to the real property that are caused on the real property. So when we look at all of those various different causes of action, there are gaps and holes that exist within the insurance policies that we have. So insurance combined with legal process, that symphony is what makes an appropriate asset protection plan work properly. Now, today, more than ever, there's been I guess it's philosophical, especially over the last 8, 9, 10 years, that it seems that if you've been successful, if you've managed to accumulate business assets, real property assets, rather than being rewarded for the success that you had, you've been vilified. Vilified by the fact that you may have done it on the backs of the middle class, that you may have done it by taking advantage of lower classes, that you did it with the help of the government. The fact that you signed personal guarantees, which Glenn will be talking about, financing of real estate later on in the seminar. The fact that you stayed up late at night, learned, attended webinars, the things that you've done, that you've risked everything, including relationships with time, to be successful. And now you are successful, so rather than be rewarded, you're vilified. So you wind up with sometimes having a target on your back, and sometimes that target is the real property that you own. So given that set as a backdrop, I've had a philosophy for many, many years that indicates to me that we have a broken legal system, but at the same time, we probably have the most sophisticated legal system in the world. That combination to me is inherently dangerous. So today, what we're going to talk about very specifically is real property. And when we talk about real property, I'm going to kind of share with you the things that we have seen over the years and the sort of cliches that we've heard over the years when it comes to protecting our real property. Well, I think the first thing we need to inherently understand is a lot of legs on this spider, and I'm going to try to cover each and every one with them. Now, first off, when we talk about real property, we need to understand the concept of inside liability and outside liability. So when we talk about inside-out liability, this is liabilities that rise up as a result of our ownership of property. So if we're the landlord, we have tenant problems, mold problems, have problems existing with people getting injured on property, fire on the property, lack of carbon monoxide detectors, dysfunction of carbon monoxide detectors, and it goes on ad infinitum. This is a result of our operations of properties. So in which case, the tenant, especially in California and other more liberal states, will immediately attempt to sue the landlord for the damages that come as a result of that. And the courts are all too, I would say, liberal and I think in my personal opinion, independent bias in the favor of the tenant. And so the definition that comes about is who's the landlord? Well, if you are the landlord individually, husband and wife, each one tenant, you as an individual person, husband and wife, depending on where you are in the country, is tenants in by entirety. If you are in the form of hold property in the form of a general partnership, if you have property held in your living irrevocable trust, that liability is unlimited to you personally. Meaning, you could lose your house, you can lose your business, you can lose your bank account, you can lose everything that you have. We see that all too frequently. We see it was the second home that we didn't sell, we rented out, and now we turned around and kept that in our living irrevocable trust. This is not a good thing to do. We'll go along with one of Harry's axioms, that if you're going to be in the business of rental real estate, you should never be in the business of rental real estate as a sole proprietorship. So when we look at that, how and what should be the best way to hold real estate? Well, I think it's really important to hold our real estate in some form of a limited liability entity. And they come in different forms. They come in the forms of corporations, which, by the way, are not very, very effective for tax purposes, whether it be C corporations or S corporations for the holding of real estate. Very commonly used entity, a limited liability company, and another form which we see commonly in the form of a limited partnership. Understanding that a limited partnership is an unlimited liable general partner, so we have to be concerned about liability there. So if we have a piece of property that has $900,000 worth of equity in it, and it's properly encapsulated within a limited liability company, and we have a real estate, that particular real estate related liability, then the maximum, I'll say should, the maximum recovery that should be available by the plaintiff would be the value of that landlord, which is that limited liability company, which would be that $900,000. Now, again, if it would be sitting in a living irrevocable trust, it would be your entire net worth right up through, including your bankruptcy. Now, moving along a little further in the situation similar to that, here's what we see. So people will say, well, you know, I have 3 or 4 pieces of real estate, and they'll ask me a question, can I place that real estate, those 4 pieces of real estate within a single limited liability company? And the answer is, or limited partnership, and the answer is yes, you can. At this point in the workshop, we're pretty much going to ignore placing real estate within corporations. Glenn will probably fill in a little bit for you from the tax position why that is probably not a good idea. Would have been a mistake, and maybe you could chat with us about rectifying that mistake. But so the answer is absolutely. But we need to think about that from a business and an economic perspective, placing 3 or 4 properties. We'll use my earlier example. So let's say we had 4 properties, each property worth $900,000 of equity. Remember, real property, I don't care if it's a $2 million property with a $1 million mortgage, your value is the equity in the property. So if we have 4 properties, and we'll call it ABC LLC, then we have in that LLC $3.6 million worth of equity. So we've combined, or that landlord now has $3.6 million worth of equity. And every single tenant and their invitees and their guests that become targets against this larger pool of equity. So I have 4 different properties, all the people in operations in those 4 properties against a larger $3.6 million equity. So many people ask us, is that good? Well, it's okay, but I think it would be a lot better off, I think you would too, if we had that segregated, this is just common business sense, not so much asset protection, into 4 separate limited liability companies, each with no more than $900,000 worth of equity. And that would mean that a liability of property A wouldn't take down properties B, C, and D. So I think that's just good divide and conquer and diversification that should be examined. Well, when people say, well, I'm going to have to pay $800 in fees, and I have to pay, $200 or $300 or $400 for a tax return, I strongly suggest that those numbers or those costs should be actually built in to the lease pricing that you are providing to your tenants. And 2, they're deductible expenses, and 3, they're very small insurance policies to pay in this area, which is a particularly hot area in asset protection. So looking at that, I think that we get an example of how that should be structured. Now, there are myriad different structures on how that could be done. In some states, they use series LLCs. In some states, the use of limited liability, limited partnerships, which are not available in all states. Different tried and true methods of segregating and doing. But, of recent, I'd like to bring to your attention some very important components. You know, one could reach into a box in LegalZoom and try to create a limited liability. I think it's very important to understand that it's not just the creation of the entity that provides us with the asset protection. Excuse me. It's also the way in which we operate our business. So, unfortunately, if we do not respect rules, we do not have a well-written and constructed operating agreement, there's always the possibility that an argument be made that this limited liability company is nothing more than your old legal. It's just true. So, yeah, we have the entity, but now what about its rules? So, if we've received the rental income from that entity or from that property, and instead of depositing it into that entity's account, we put it into that person's checking account, or we use the entity's rental income to pay bonds bills, supermarket bills, and doctor bills, not very good. And if we turn around, and although limited liability companies do not require books, minutes, records, and meetings of the members, may I strongly suggest, especially in today's judicial environment, that if we have taken the time to hold a meeting, record the events that take place in our companies, and be able to present that as evidence showing that that company is a standalone company, we have a better chance of making sure that if a judgment would be greater than the value of our LLC, that a court or the plaintiff's counsel does not attempt to pierce that veil and get through to all of our individual assets. I see that many times people have built and developed reasonably good structures with their counsel and then have failed to follow good business principles in dealing with those entities. So I wanted to keep that, as part of your lexicon of takeaways for today. Now, let's continue on a little bit and talk a little bit about what I call outside-in liability. And outside-in liability is where I think that many of us have missed the boat. The train left the station and we're just sitting there looking at the train. So let me talk to you a little bit about this. Is a liability that occurs not as a result of the operations of the real property, but comes as a result of a liability to the owner of the real property. So if Harry and Glenn owned a piece of property and it was worth $1 million, and Harry and Glenn, unrelated to that property, we were driving down the street really quick and drag racing, and the two of us severely injured some people, then the judgment comes to Harry and Glenn for us doing things we should not have done. And we look down and say, what does Harry and Glenn own? Well, Harry and Glenn own this piece of real estate. It's an asset. So what the creditor will do, they'll place it on their property, and they will foreclose on that lien and take that property away from us. So I want you to know that more properties are actually lost through outside-in than inside-out liability, one we don't think about all that much. So what's the difference between the various different? If we obviously own our properties in our living revocable trust, and we have personal liability, the creditor will reach out into that trust and take our property. If we own our property in a corporation, which Senator will talk to you about the tax attributes of that, what do we own? We own stock. And if we have a liability against us, then what's going to happen is the creditor is going to get the stock. Once the creditor gets the stock, instead of the creditor is going to be able to liquidate the company, sell the property, get the proceeds, and take complete control and reduce our property. So that leads us down to what can we do to protect our assets as best as we possibly can from all the other things in life, from 16-year-olds driving, from liabilities as an officer, director of a corporation, to liabilities just because we drive on the freeway, we own a house. So if properly structured, and it's very important to have proper structure in the appropriate jurisdiction, we can structure something which is called a charging order only entity, a limited liability company, or perhaps a limited partnership, whereby if a liability comes to you, that we hope the sole and exclusive remedy that would be available to a creditor is to place a lien over the distributions that come from that LLC as the only remedy that would be available, meaning that that creditor would not be able to reach inside that limited liability company when structured properly and take that property away and sell it. And the creditor's remedy would be to receive the distribution. But the creditor would also not receive any managerial control over that limited liability company. Therefore, the creditor couldn't even force a distribution to be made. And under certain circumstances, it's very probable that the creditor may have the privilege of paying the income tax on the phantom income that would be distributed or incurred by that limited liability company and passed through to the creditor. So it's not the best remedy in the world for the creditor, and therefore, depending upon the state in which it's formed and where you live, it's very important to make sure that we have an appropriate structure that not only protects us looking up from the real property, but protects us looking down to the real property at the same time. I think that that's really critical to understand. Now, when we look at that, which is beyond the course of the time that Ben and I have with you today, you'll find and notice that not all limited liability companies and all limited partnership structures are created equally. For example, today, under judicial pressure, consistent judicial pressure, single-member limited liability companies, although may do a reasonably good job in protecting you from liability rising up from the operations of the real estate, have been increasingly allowing creditors to reach inside and reach the assets of the single-member limited liability companies. And the reasons for that are a little bit beyond the time that I have available with you today. The other thing that we need to understand is that in limited partnerships have been around a very, very long time. And they are charging only entities. But one of the things that are characteristic, are very important of a limited partnership, is it requires a general partner. And a general partner, we've seen these all the time, it could be mom and dad, or individual general partner. Sometimes we'll see a corporate general partner. Sometimes we'll see a limited liability company general partner. And the structures we see traditionally with limited partners at 98% and 97% of the ownership interest, and the general partner with a 2 or 3% ownership, 1 to 2% ownership interest in a limited partnership. We need to always understand that the general partner of one is unlimitedly liable for any actions that rise up from their partnership. So we would sue not only the limited partnership, but sue the general partner. So that kind of eliminates, or should be eliminating, the trust as the general partner, and the individual as a general partner. And so we look to traditionally see people that form corporations to be general partners or limited liability companies. Let me reverse that with you for a second. If you've taken the choice and used the corporation as the general partner. Now let's take the outside-in liability that we talked about. So now what happens is that, we crash the car, we have a significant judgment that comes against us. I'm able to turn around and get a judgment against you. You own the stock of the general partner. I get the stock of the general partner. The general partner controls the limited partnership. And then that result is that now you could actually have an adverse party controlling the underlying real estate. A very interesting scenario. The other problem that we face so many times, Ben may touch upon this a little bit, is that in the general partner, limited partner relationship, it's very important that the limited partners really have no participation in the management of the structure. And we see more and more times where limited partners are actively involved in the management of that, and especially in small real estate programs, and which in essence, ladies and gentlemen, can turn you from a limited partner to an unlimited liable general partner at the same time. And I don't think you'd want to see there in a deposition or in a courtroom talking about your level of activities, level of management that's involved in order to do that. And one of the things that can require bring to your attention is that there's kind of a pressure to be kind of actively involved for losses and gains to be used more effectively from an income tax perspective. But what happens when we do that, we also jeopardize them because we are limited partners. So limited liability companies have a much better perspective for you in that area. And what I want you to all understand is that for those of you that own real estate individually, with relatively easy to place those into limited liability companies and structured properly. There'll be no reassessment. There should easily be no problem with lenders. Now we work with them to make sure that that's done. And I want you also to understand that from a tax perspective, usually just a few extra dollars in LLC fee. Now it's beyond the time that I have with you today to discuss whether or not it should be a California, Nevada, or Delaware limited liability company. And there's really good arguments of why limited liability companies not being used in California or in states that have what we call foreclosure remedies to use states that don't have them. Please understand that no matter where you form we'll call it the governance of your limited liability company, it needs to be registered to do business in the state where the real property is located and pay tax. So sometimes you always hear, oh, we'll form a Nevada limited liability company that we get out of having to pay California tax. That is absolutely not the case. In order to receive under California law the protections, for example, of the Nevada limited liability company. So again, I think it's really important to have process. I think it's really important to have appropriate procedure. I think it's really important to analyze the structure around your real property. And something that's very interesting that we're going to talk about when Glenn takes over, I believe, is that now once you've formed the limited liability company, and once you've transferred the property into the limited liability company, so if you had a property that had $1 million worth of equity and no lending against it, then what would happen is if we had a landlord-tenant liability, we have $1 million worth of exposure. So here's the point. Now, we now have the ability, for example, to go down, if a lender, and say we'd like to borrow $500,000 or $600,000 out of that property or out of that LLC, and so we can reduce the exposure to the tenants within that group. But now that becomes a lot more challenging. Lenders have lots of conditions, restrictions, covenants, and it has to be done the right way. And I can tell you, I've worked with many, many colleagues over the years, and you're about to get an opportunity to hear from one of the top real estate agents, real estate attorneys, who really understands the utilization of loans, credit, loan documentation, security interests, and really important to understand this. He schooled me a few times on how the various different covenants and restrictions work and the things that you should be looking for and protected against when we go to borrow money for and or against real estate. So I hope I've given you at least a modicum of understanding of asset protection in the real property world. We give you a comprehensive analysis. We take the next 3 months or 3 years to do that. However, we will be more than happy to speak with you individually and help that. And with that, I'd like to turn this over to my colleague, esteemed colleague, Glenn Fuller, who's going to talk to you about the other side is how do we get the money out? How do we deal with the dealing with that? What should our operating agreement say and our loan documents look like? You're really going to enjoy this. Good play. Thanks a lot. Thank you. Thanks,
Hi, everybody. My name is Glenn Fuller. Thank you so much, Harry. I really enjoyed that as always. We're having some audio problems, so hopefully everybody can hear me. I'll speak up a little bit. And something else, I know it's not very interactive normally, but Harry, if you have any questions, Harry's sending to my right here, that you think I need to go into a little bit more that our audience will have, please share that with me. Feel free to interject. I like to keep things a little more, have a little more dialogue. Hopefully, we don't just be throwing it on. So, just want to follow up on some of the things before I get into some of the what I call credit enhancement issues that Harry mentioned. And he mentioned I would extrapolate a little bit on some of those topics. I think it dovetails very well into what we're going to talk about, the credit enhancement. But there's really two things that you find in every real estate deal. And I focus primarily on real estate. We do other partnership, LLC type transactions as well, but I'm at heart am and hope to always be a real estate lawyer. It's really what I love. And what I love is very much along the lines of what Harry does as well is the planning. and working with people. I've been doing this longer than I want to admit, but over the years, if there's a few things I've seen, it's the people who come to us when, and Harry, I'm sure, gets this all the time, when there's really not a lot you can do for them from the perspective that they signed a non-recourse carve-out guarantee. We'll get to what that is in a second. That said they won't put their entity into bankruptcy. They already put their entity into bankruptcy, and the lender's suing them. Other things like that, once they've already breached a covenant. The way that loan documents are drafted now, and the way that the guarantees are drafted, once you've sort of committed the act that puts you into that realm, it's very, very difficult to write that ship. And the way that these guarantees and loan documents are drafted, you pretty much waive your legal rights. Most people, a lot of people don't want to hear this, but generally the more successful people who've been doing this for a while realize is planning is key. That's why Harry and I are doing this. It's why we really encourage it's not just to be self-serving, but there's two areas where planning is absolutely critical in both the life of a real estate company and when you a real estate asset. One is the entity formation, as Harry was talking about. What kind of entity are we going to have? How are we going to capitalize that entity? How are we going to govern that entity? And how do we deal with all the idiosyncratic nature of the different either members, partners, other people? And in my case, I end up about 50-50 where I represent developers, entrepreneurs, very successful people who are bringing in outside money. And then another big part of my practice and my firm is we represent a number of investment groups and investment entities whose job it is to place money, pension fund money, other money, and they're looking for these entrepreneurs. They're looking for opportunity. And the bigger stick you have to wield, meaning the more money you have, generally the more negotiating strength you're going to have with the entrepreneur, and vice versa. Once you've shown that you can be successful, and once you've shown that you have a good track record, it enables us as the attorneys to go to the capital providers and maybe get a better deal for you. We won't talk about, that's a whole other seminar topic, very interesting topic, how you negotiate those, but let's talk a little bit about the entity formation that Harry mentioned. I just want to touch on this. It's not meant to be the main thrust of my talk here to everybody, but it's a good opportunity to follow up on some of the things that Harry mentioned. One is the right entity to own real estate. And really the question that I look at first is, and I think is a gating issue, is corporation versus what's going to be partnership taxation. And 99% of the LLCs that you will deal with in real estate or more are all going to be taxed as partnerships. And when you form an LLC, you have the option, do I want to do this as a partnership or do I want to be taxed as a corporation? Absent really extreme circumstances, I'm talking really extreme in the VC, venture capital context or others, you're always going to be taxed as a partnership when you have an LLC. Partnership taxation is the distinguishing characteristic. There's really two types of corporations that are available under the federal tax code. One's called an S Corp, which is S for small businesses. They do not have the double layer of taxation, but it's a very, very difficult structure to alter profits and losses, to distribute money, to bring in new money, to offer what we call promote to the entrepreneur or the promoter, which is a separate interest that they get for what they, their sweat equity. It's impossible to do in the S corporation. Plus, when you do a distribution, it's extremely difficult. And what's called the C corporation has a second layer of taxation where you get taxed at the corporation level, and then you distribute to the shareholders, and you get taxed again. Most people don't want to pay double level of tax. The math on it is pretty horrible. So, and also there's other ways with respect to the opportunity to do what we call distributions in kind, where you get a piece of the real estate instead of money. And that enables us to do tax planning for 1031 exchanges and other things. We can't do that in a corporation context. So let me touch a little bit on the partnership LLC. Now, from my perspective, not talking about the liability perspective, but from how do we form this, how do we govern it, what are we going to do, they're virtually identical because if they're governed by partnership taxation, which means that the nomenclature is your general partner in the limited partnership context, is what we call the manager in the LLC context. The big difference is that in an LLC, everybody, meaning the managers, the members, are all theoretically supposed to be protected, and this is where we'll distinguish from any of the liabilities of the entity. So Harry and I form a LLC. We bring a third party to be the manager. We're both 50-50 owners. The theory is that if something goes really wrong, we could say, here's the key, and we don't have personal liability. And that's where, and a lot of people, unfortunately, believe that that's the case in all circumstances. It's not in two very, very important circumstances. One is, and we don't have time to talk about it today, is your tax liability. If your entity goes down, the property gets retaken, and you lose it, especially if you're doing 1031s or other type of tax planning, you could really be looking at a devastating tax event, even though you don't have personal liability or liability to the other creditors or anyone else. You're looking at that. And the second issue, and a lot of people, this is one where this really seems to be probably more than anything, is signing guarantees. And guarantees are a very, very common, and I'll explain why, form of credit enhancement in all jurisdictions where in the United States where real estate is used, for a very good reason. It enables the lender to have a sure creditor they can go after, and it's also gets us around, and I'll touch on this in a minute, what we call the anti-deficiency statutes that California and a number of other jurisdictions have, where if you foreclose, you're a creditor, you take back the real estate, you're prohibited from going after the owner of that real estate. Now, the reason for that is, you think about the Depression, people lost their house, the bank is foreclosing, they send somebody to bid $1, the bank gets the property, then they turn around and sue the former homeowner for the rest of the money. And as a public policy, California and most of the other, a number of other jurisdictions have said, look, we will give you, lenders, the right to secure your lien against the real property. And when you do that, you get to do, and if the people who are involved with real estate, they understand, if you do the trust, that gets reported in the county reporter, and it's deemed what we call constructive notice. The whole world has noticed now that you as a lender have this lien, and so anyone else who puts any debt on it or anyone else who comes after you, you have what we call seniorities. And those are huge, huge advantages. Plus, as a secured creditor, if there's a bankruptcy, you're considered secured in the bankruptcy, which is another big advantage. So the public policy is, because we give you lenders so much control over the, because we give the lenders so much advantage to say, you get a real estate secured loan, you get all these other things, but we're not going to let you go after the individual the owners, which sounds like a great thing if you're an owner. Now, in the residential real estate context, that's in every deal that you do. When you get a deed of trust on your house, you're not personally liable for it. Everyone knows that. However, in the LLC and partnership context, it's not unusual for guarantees to be demanded for the principals or people that they think have a bigger balance sheet in order to make the loan. And one thing that I'm hoping that will be a takeaway here, we can't go into everything, obviously, but one of the things I want people to understand is that all loans are not created equally. All loans don't have the same terms, and it's not off the rack. These can be negotiated. And unfortunately, a lot of times when something comes to me, it's through a loan broker or through some other relationship, and they've already talked about it. Generally, I think this is a theme that both Harry was saying, and I'm trying to say, is the earlier you get us involved, the more we can help you out with. And so when I look at people who are looking at loans, and doing a lending package, there's various banks and various lending institutions who are in that business, who might be providing those types of loans, who might be interested, and they sometimes have their own threshold for what their risks are with respect to credit enhancement and with respect to guarantees, and those are very different. Those are very, very different, and we'll go into some of those right now. So one of the key distinguishing things when you have what we call the anti-deficiency statutes is that, so going back to our example, Harry and I form H&G LLC. We go out and we buy an amusement park in Valencia. And when we do that, again, the LLC itself doesn't have any deficiency problems. But what those of you who have engaged engaged in any commercial loans will see that one of the first things the lender says to you is, we want a separate entity to own the real estate. We either want a corporation, probably acceptable to the lender because they don't care. But 9 times out of 10, they want a partnership or an LLC to own the real estate because they want a separate liability company to own the real estate. So you might be thinking, wow, look at the lender. They're being great. They care about my liability. Well, no. There's 2 reasons why they do that. One is something that Harry touched on before, and that we call bankruptcy remoteness. That when there's a bankruptcy, what happens is that the bankruptcy estate goes in and they try to grab all the assets of whoever's bankrupt. And what lenders have clued in on, and what anyone who does this kind of work should clue in on, is that very, very important. A lot of the work that Harry and I do is to keep these entities that we call bankruptcy remote and distinct so they don't get consolidated in bankruptcy. So we have H&G LLC in my example, and Harry has other investments, other LLCs that I might be involved in, I might not be involved in, but we say, H&G is not working out, we want to file bankruptcy. The more assets we have in H&G, the more the creditors are going to be able to go after, which was Harry's point before with respect to not commingling all of your assets, because that's just, it really, really is one of those situations that can create extremely, extremely difficult situation, because a bankruptcy trustee is granted tremendous powers, and they will go in, and we've both been involved in this before, they'll go in and they'll try to grab as many of the assets as we can, and the better Harry and I do setting you up for that eventuality, the better you're going to be. Now, why do lenders care about that? Well, I'm a lender, I'm making a loan on this office building I'm sitting in right now. I don't care about everything else. So I want to know that if H&G LLC declares bankruptcy, I'm going to go in and I'm not going to be fighting with a bunch of other creditors. They're going to say, no, that belongs to me. I want to know that as a lender, I'm the only lender on that property, and that H&G LLC hasn't gone out and financed and brought in a whole bunch of other properties into the entity. And now, the more sophisticated lenders, I do a lot of multifamily lending, for instance, and it's ubiquitous now in these loans that we have to put in the operating agreement or the partnership agreement, actual covenants. We'll get to some of these covenants later, that you cannot own any other real estate except for what this LLC owns. And that's how important it is to the lender. Again, it's for their protection, not yours. Now, the second reason that they're doing this is that they want to know that if there's a foreclosure, they can foreclose on the property and then go after the people. And remember I said that, I'll use California as an example, a lot of jurisdictions follow it, is that in California, they come in and they foreclose on this building. They can't come after anyone, Harry, me, the entity, unless there is some sort of other agreement that we can do it. Now, what people used to do is, okay, H&G LLC would do the loan documents, we'd also sign a guarantee. And the California courts being, as Harry mentioned, and I think this is courts everywhere, but practicing in California, I could definitely attest to this, is that they're not just pro-tenant friendly, which you'd expect, they're also very pro-borrower friendly, okay, which means that that lenders are going to go in and they're going to tie up things as much as they can. So the California court said, wait a second, if you're guaranteeing your own loan, that's just a way around that anti-deficiency statute. We're not going to respect those guarantees. They're called sham guarantees. They're specifically not allowed in California law or enforceable. So when the lender says, oh no, you have to put it in a single member LLC, or not single member, I'm sorry, you have to put it into a distinct, what we call SPE, special purpose entity. That is because they want the bankruptcy remoteness, but they also want to know that any guarantees that get signed are going to be signed by the individuals, not the entity. So in our case, they might say, well, geez, Glenn, your balance sheet's not great, but Harry, he's looking good. So what we're going to say is Harry has to sign the guarantee of this loan. It could be, and we'll talk about all the different types of guarantees. It might be Harry, it might be me, and you know what? It could be a third party. And I do have clients in larger transactions where we actually will pay for credit enhancement. We'll go out and we'll pay a larger company with a bigger balance sheet to actually guarantee our loan, and then we pay them for that guarantee. So there's all sorts of different things that lenders will look like for that perspective. So let me move on now to some of the specifics with guarantees and how that works, is because what everyone is probably familiar with is what we call non-recourse, full non-recourse guarantees. And those are, I guarantee everything from Any losses that the lender has, the guarantor fully and will guarantee it. And so losses, attorney's fees, anything else. So those are actually not as common as you would think. Generally what we have today in California and in most jurisdictions is what we call non-recourse carve-outs. I don't know if anyone out there is familiar with the term, but essentially what that says is the loan is non-recourse to the principal, to the borrower, but we're going to put in what we call carve-outs, meaning these are certain situations where we're not going to give non-recourse liability. Now, by statute in these states, it's still, they have to give it to the borrower. It's still in the loan documents because you never know, the law could change or a case could come down, it can change. But the real issue there, and what we need to look for very, very carefully, is they'll take those non-recourse carve-outs and then they will make somebody sign a guarantee of those non-recourse carve-outs, just those non-recourse carve-outs. So what are those? Okay, so some of the more common ones is bankruptcy that I just mentioned. That is one, by the way, that I see all the time. And if we ever work together and we have this, you'll see I fight this tooth and nail to get this out. Essentially, it says if the entity declares bankruptcy, I can come after you, guarantor, personally. Well, let's look at an example where, again, H&G LLC, it's not just Harry and I, we also have 10 investors that came in, all right? And Harry and I look at each other and we say, we just lost our biggest tenant, had an uninsured loss, nobody could have foreseen. We need to put this entity into bankruptcy. It's the best thing to do for our investors. Well, then we turn around and the lender says, oh yeah, guess what, guys? Now you, Harry and Glenn, are personally responsible for all of the liabilities of the entity because you put the entity into bankruptcy. That was a non-recourse carve-out. And where I fight that very hard is to say, well, wait a second. If I'm a manager or a general partner or affiliate of a general partner in the entity, and the best thing for my investors is to put it in bankruptcy, you're saying that I either have to protect myself by not putting it in bankruptcy and hurting my investors and breaching my fiduciary duty to them incidentally, or declaring bankruptcy and then having full personal liability. And I fight that one very, very hard. I was actually, last year, was on the phone with the general counsel of a very large insurance company, and we were able to get that out. But those are the types of things you really, really have to think about. And they run the gamut. Now, some are just, you should be doing this to run the real estate anyway. So, for instance, I didn't pay the insurance bill. I didn't pay the property tax bill. Those types of things, those generally they'll want the principals to be liable for. But another one, for instance, is called waste. Waste means that the diminution and value of the property is a very, very broad standard, and that could easily come back and haunt you depending on the type of real estate. Now, the other thing we didn't touch on a little bit here, used to be a very, very hot issue. I'm just going to touch on it briefly so people understand it, is environmental indemnities. Environmental indemnities are almost always entered into in connection with real estate secured loans from larger lenders. Essentially, it says that the fear is always, well, if we take back the property and it's, meaning the lender, and it's contaminated, then we're going to have a situation where the property might be worth less than our lien. So California and other states say you can actually walk away from your lien as a lender and then sue directly for the environmental liability. And back in late 80s, early 90s, through the mid 90s, that was a real concern in California because, and other states that had highly industrialized real estate that was being repurposed. The classic example is your service station, right? You used to do these tank poles at the service stations that have been around since the 60s and 70s. They see there's something out there. Because of the regulations, you have to go in and scoop out how much dirt. You have to do this many tests, and if it gets in the groundwater, they get involved. And that was expensive. It was difficult to do. It created a lot of unknown liability. And as time has gone on and people have gotten much more sophisticated about environmentally contaminated property, you're seeing that fear abate. Not that the fear isn't still real, but for instance, I just did a loan with a very large lender on property actually not far from here, where it's a laser essentially manufacturing because a very high-end thing, but it's on property that had been shut down for environmental reasons, And all we had to do, it had all been cleared out, but all we had to do is enter into a covenant that we would never use it as a residence or a school or covenant or these types of uses that they consider that might be more dangerous for the public. But these properties are being repositioned, they're being repurposed, and people say it's not the end of the world. And so increasingly, that is becoming less and less of an issue. But those environmental indemnities are also oftentimes guaranteed specifically in the non-recourse carve-out. So before I get to the other types of guarantees, let me just touch a little bit on these non-recourse carve-outs in the conjunction with what we call CMBS, commercial mortgage-backed securities. Now, again, hard for me to tell without the feedback how many people are familiar with what we call commercial mortgage-backed securities. But what these are is that this started with home mortgages. If anyone read Liar's Poker back in the 80s, that they started with home mortgages, putting all the mortgages together, and then taking the income stream of those mortgages and selling them as bonds, selling them as securities to investors around the world. And it went from being pretty much nothing in the 70s to one of the largest Wall Street departments. Every investment house has a huge mortgage-backed securities department now. But instead of just doing residential loans, the financial companies got into doing these for commercial loans. Now, I don't know if there's any lawyers out there, but one of the first things we learned first day in law school is that every piece of real property is unique according to the law. So I have corner A, you have corner B. We can't just say, well, they're the same thing, just take them, because traffic patterns are different. Everything's different about real estate. Every piece of real estate is considered unique. Yet, as a principle of law, we're putting all of these together. One giant bond, and we're going to sell them to investors, so we need these to look and act very much the same, have the payoffs be the same, have those types of things. So it led to a lot of standardization of the loan documents, what you could put in, what you couldn't put in, what I could negotiate, what I can't negotiate. But as sort of a trade-off for that, the CMBS loans are almost never, I've never run across one, what we call full recourse. They're always limited recourse loans, and we call non-recourse carve-outs. And that's what I touched on before when I said the bankruptcy, not paying the insurance, those types of things. And they also extend to what we call bad boy acts, is the vernacular for it. Taking rent checks and you're supposed to put it in a lockbox for the lender, instead you put it in your pocket. You do things like that, those things can drive the loan to be full recourse. But the theory is, with those, is that if I'm just doing my job as a real estate operator, and I'm not doing anything wrong, and I'm leasing the property out, I'm trying to do the right thing, and then we have a downturn in the economy, we have a national catastrophe, anything can happen, and I lose the property for not want of having done anything properly myself. The theory is that we don't want the borrowers in those situations to have full recourse liability. We want those borrowers to be able to walk away from that real estate. But if the borrower hasn't been doing what they're supposed to do to maintain the asset, to comply with the loan, and so forth, we want the ability for, we want to be able to go after those people, and thus what we call the non-recourse carve-out guarantee. They're very, very common now. Again, if you're involved at all in this it goes back and forth. A lot of people like these commercial mortgage-backed securities because they're cheaper. They get a few points off. I hate them. I try to steer people away from them because, first of all, the guarantees have gone from what we call traditional, as I said, non-recourse. And as happens, as time goes on, the lenders and who are in this space have continued to push the envelope of what the non-recourse carve-out guarantee should be, and it's becoming more and more of a fight every time to limit the guarantee. And again, what I just said is the pushback I always get from lenders is, if we're not doing anything wrong, we're doing everything we're supposed to do for the real estate, but it doesn't work out, we're not supposed to be liable. I'm seeing more and more non-recourse carve-outs that essentially eviscerate the whole concept of it being non-recourse. So you have to be very, very careful. Don't just sign what they give you. And then there's things like bankruptcy and other things that we need to look at, as I talked about. So before I start talking about some of the other types of guarantees, I want to backtrack a little bit to, we talked about the entities, and Harry very astutely said that with respect to when you have entity formation and you're doing that, and who has rights to what, who has informational rights, who gets voting rights, who gets say on things, that's always, it depends on the negotiating strength of the parties. A really, really good real estate operator with a really, really good track record and people are trying to get in will say, this is my operating agreement, take it or leave it. Or this is the operating agreement we've done for the 5 other deals, you've done them with me, I'm not making any changes. When you're starting, say you might be willing to give more changes, or if you have a special investor that's going to come in and give you a huge part of your investment pool, you might give them extra rights, you might give them that they might not have, and a lot of times those are driven by, in turn, their investors and what they require in order to be able to say, I've had people say, look, we can't do this deal with your client, Glenn, unless we get the right to force a sale within 3 years because that's our investment timeline. All legitimate, valid reasons, and that's all part of the negotiation. One of the things in the negotiation that I don't see enough of is what happens if I'm liable for under the guarantee, meaning any party that is liable. I have seen things being as crazy as people will form a limited liability company, and then every single member will sign a full non-recourse carve-out guarantee. And I look at those and I say, well, why would you do that? You take individual liability, you put it on yourself from loan that you wouldn't otherwise have. And other times I'll see somebody who may not have as much to gain. Somebody might be a smaller interest holder, and they will sign a guarantee and not really have anything corresponding with it. So 2 issues that I wanted to bring up. One, just briefly, is a guarantee fee. It's not uncommon for the party providing the guarantee, particularly if they're a larger company and depending on what they're providing, to expose what we call their balance sheet to our guarantee. In other words, they will say, we'll be fully liable, but we want a fee from that. The standard one I see is usually 1% of the loan amount per year, and the other aspect of that is it's not just them being greedy, that a number of times, if you can get a better guarantor, you can actually get a better rate. So you're paying them for that. You get the arbitrage on maybe getting a better loan than you would otherwise not be able to get if you didn't have that guarantee provided. So, but one of the things that is not, I see not addressed very well oftentimes in documents is what happens when those guarantees, if somebody gets sued under the guarantee, what is the obligation of the entity or the other members to indemnify the guarantors? So getting back to our example, can use our H&G LLC, has a nice name to it, I think, here, is we're doing something and we say, okay, Harry and I will sign the guarantees, but I want our 10 theoretical members to indemnify us individually if something goes wrong. Well, if I represent one of those members, I'm saying, no way. I'm a passive member. My client is investing $500,000 in this project, and that's all that their liability will be. Now, there might be issues where if you need additional capital, we have additional capital call. I understand those things, but they're not going to be liable, including Harry and Glenn. If you guys go out and you do something and it impacts the guarantee, you guys have to pay for it. And you know what? We're here because we trust your expertise, and you're not going to do that. One of those arguments is hard to overcome. Now, one of the things that you're seeing more and more with these types of documents, particularly the more complex loan structures, is that there's what we call, and Harry mentioned this before, in the loan documents, operating covenants. Now, these covenants can be, you have to maintain a debt service, what's called a debt service ratio of a certain amount. You have to maintain earnings before interest, depreciation, so forth, of a certain ratio. Maybe you have a key tenant that you have to keep in, all sorts of other things that will be built into the loan as operating covenants. And those can be, now in other words, and we'll get into, this is transitional to the different types of guarantees. Maybe you have a guarantee that says, if we go under a certain debt service coverage ratio, we go under a certain net operating income, then the guarantee gets impacted. Those types of things. But one thing that I think people aren't nearly careful enough about is they'll negotiate the operating covenants. In other words, we have to do certain things or a loan will fall into default, and they don't realize that that could lead to, so for instance, in my example, and I've actually bring this up because it happened, is there was a loan, which thank God I didn't negotiate, but we were working out later, and a large retail chain had gone bankrupt. They did what we call reject the lease. They went out, and that was actually a covenant in the loan that they could have a default. They could declare the loan in default if this entity wasn't a tenant or they terminated beforehand. And we had a real problem with the lender because the lender was very, very pro-lender. And these guys essentially had guaranteed, the people who were eventually our clients, had essentially guaranteed a covenant that a third party, this tenant, would actually be in business. Now, and this was something completely out of their control. This was a bankruptcy filed in 2008 back in Delaware, yet they were fighting for their financial lives because they didn't go to Harry and didn't get set up correctly, because if all these properties went under, they were going to, and they weren't able to work something out with the lender. Not only they were going to foreclose, but they were going to also sue them individually under the guarantee. Another thing that we should be careful of is a lot of times lenders have what we call negative covenants. I mentioned one before with respect to you can only own this real estate. You can't own any other real estate except for the real estate that this SPE owns. And there's various things. Sometimes you have to do certain things to ensure that the money goes into what we call a lockbox, and then the lender will take it out of that lockbox, and other things that as a entity you're not supposed to do as a borrower. Those will also oftentimes trigger these non-recourse carve-outs. So I know I'm throwing a lot at you and a lot of different terms, but the real moral of the story here, before I move on to some of the specific guarantees, is that these are not off the rack, okay? You absolutely have to be careful with these. When you sign a guarantee, now one thing that we really don't get to change a lot because lenders will not change it, and I understand that, is that when you sign a guarantee, you're waiving what we call your statutory remedies, oftentimes statute of limitations, other things. You're also waiving your common law defenses. And then there's all sorts of statutes in every state that deal with notice requirements, other things. Those are all waived as well. And in that, before I move on to some of the specific guarantees, one other thing I did want to point out to any of you out there who might not be a principal but are thinking about being pressured to have a guarantee, or you're thinking a guarantee might be a good idea, or you might get a better rate, is that realize that once you do that, there's going to be an assumption in the guarantee documents that you, and you're going to actually waive this, are kept up to speed on the borrower's activities, the borrower's financial condition, and that the borrower can go out and modify those loan documents, do whatever it wants, and you're still on the hook for the guarantee. No one's going to want to no lender is going to want to come along later and say, well, gee, sorry, you signed a guarantee, we negotiated something else with the borrower, your guarantee is no longer void. They're going to have very, very strict language for that. Oftentimes, they'll require the guarantors to re-ratify it, but you're going to waive those provisions anyways. So if you're ever in a situation where you are being asked to provide a guarantee secured by real estate, absolutely make sure that the documents, the governing documents, require that you will be provided with various information with respect to the operation of the entity, with the operation with any of the assets that the entity owns, but also that you have veto rights to any changes to the loan documents or anything else that could come along and prejudice your rights. Because if you don't have the right to either have your say, have a vote, or veto any kind of change, the borrower can come along and make a change with the lender might not be for your benefit. Okay, so it's very, very important that you be out in front of these things and you be proactive, because I'm telling you, once you sign a guarantee that has all this language, and it's a real up, you're putting a lot at stake. The other thing I would absolutely encourage everyone to do before you do this, have a consultation with Harry, sit down with him, and know which assets you're exposing. Okay, if you sign a full non-recourse carve-out guarantee, you could be liable for all of your assets could be subject to the guarantee. And you might think, Harry used the example of a living trust, which unfortunately is a real misconception we see all the time, that people think that's an asset protection device. Unfortunately, it's not. But you might have thinking, hey, I've protected other assets, I don't have to worry about it before I sign my guarantee. Again, I would really, really encourage you to talk to Harry, make sure that you absolutely know what assets you're putting up, what of your balance sheet you're exposing before you sign a guarantee. So I'm going to move on now to something a little more technical. We're going to talk about some of the other types of guarantees you might run into out there. But before I do, Harry, do you have any questions? We don't have the feedback, but
doing absolutely great. You've covered all the very important areas and emphasizing everything you both do.
Great, yeah. So that was just because we're talking here, and I don't do these as much as Harry, so I want to make it interactive for everybody. So I again invite Harry. So something you think I'm not explaining well enough, or maybe you find interesting, want to go in a little bit more, let me know. So, sorry, so let's talk about some specific types of guarantees there. We already talked about the non-recourse carve-out guarantee, which is a guarantee with, again, that you run into with commercial mortgage-backed security. You run into them in other contexts as well, but though that's really where you're going to see those types of guarantees. The other guarantee, now talking about full recourse for a second, a full recourse guarantee is we're going after you, we can go after you for all the liabilities we enter. Sounds pretty bad, and it is. However, there's lots of things we can do and nuances we can look at with these guarantees. For instance, we have what we call sometimes first dollar and last dollar guarantees. Those guarantees, so in other words, when the lender takes a loss, do I start as a guarantor? Do I have to pay the lender for their earlier loss, or do I have to pay the lender as a guarantee as we get closer to the end? We might not know what those are yet. Another carve-out that we often put in here, and that's just something I always try to get, is what we call burn off the guarantee. So one of the main reasons, and this comes up a lot in the leasing context too, is you say to the lender, look, you don't know H&G, so you don't know our operating history, but we don't feel like we want to have our guarantees out there forever. So we'll guarantee, each of us will guarantee 250 grand. Each of us will guarantee 5, whatever it is. And then over the years, as we perform under the loan, we burn down that guarantee. So every year we have another $100,000 that burns down, something else. That either comes to a halt at some point, or maybe we reach a threshold where we're always going to be somewhat liable, but we go from $750,000 of individual liability to $250,000 of individual liability. Maybe we go to zero over the years. And the argument I always use with when I represent the borrowers is exactly what I said is, well, once we perform for a certain period of time, once we've amortized down the loan for a certain period of time, it's not fair to keep us on the hook because we've already shown that we're performing, that we're good borrowers, that we've basically lived up to our end of the bargain. And that's something that we've been oftentimes very, very successful in negotiating, something like that. And then the other thing that you could do with those types of loans is, with those types of guarantees, is you limit them to certain conditions as well. So, for instance, one of the things I mentioned to you before is debt service coverage ratio issues, operating covenants, other things. And so when a lender makes a big deal about that, and they start saying, well, we're not sure if you're going to do that, we're going to do this, we can say to them, we call it what we call a springing guarantee. So we say, we'll sign something now to say we're not liable unless or until an event happens, okay? Oftentimes that event is something, an operating covenant, something else that happens that we have to do to reposition the property. I just did one now. We actually did a complete workout of a loan where we went in with the lender. One of the things the lender did is they basically, in our negotiation, we said we'll be able to lease out these floors in this office building within a certain period of time. If we didn't, a springing guarantee would have gone into place because they thought that the foreclosure risk would have gone up so much more. So they gave us 2 years to lease out the property subject to certain criteria, and we were able to do that. But we did one of those, we'll put our money where our mouth is kind of argument. We say, okay, we won't sign a guarantee now. We're so sure we'll be able to do this, but if not, so we signed a guarantee saying, in 2 years, if we don't meet these covenants, then our guarantee comes into place. That's called a springing guarantee. Those can happen both in the context of an event, something you're trying to establish, something you want to do, and it comes into issue when you have a situation that I mentioned before. Say, in our operating agreement, we're not allowed to own any other real estate, and we bring in other real estate. There's a foreclosure, And all of a sudden, lender A, who thought I was a lender, they're fighting with a bunch of other lenders saying that they own part of our property. That's a springing guarantee in that situation. Because of that event, we might be liable. So one of the things you also really need to look for there is, what are we liable for? Okay, that's another thing people don't focus on nearly enough, is that if you're liable for under a guarantee, it doesn't mean that, again, that you're liable for all the damages under the guarantee. So, for instance, if we violate an operating covenant, one of the key distinctions is, does that make us fully liable for the what could happen alone? Or are we now looking at a situation where the lender has to go out and hire an attorney, they have to hire a bankruptcy attorney, whatever, it costs them $300,000. Are we only liable for the damages that flowed logically from our breach? And that's something else that people really, really need to look at. And particularly in the bankruptcy guarantee, other things, they need to absolutely be careful to say that, all right, maybe I can't get the bankruptcy carve-out, but it doesn't make the loan fully liable. I'll only, because say it goes into bankruptcy, we're able to pull it out of bankruptcy in 90 days. We'll pay you, lender, your reasonable attorney's fees and losses for that event, but that doesn't mean it's fully recourse for the rest of the life of the loan. Very, very important thing. Something else you may have seen in construction context is something called a completion guarantee. Now, lenders do not, again, they're primarily always want to, and something we're talking about the guarantees, we're talking about these things, but really a lender in the real estate context primarily is going to want the real estate is going to be their main source of collateral, and they're going to look at that source of collateral as the only, when they underwrite their loan. It's very, very risky, therefore, for a lender if they do that and you're doing either full-on construction or major capital improvements construction, because if a borrower is in the middle of that and the borrower defaults and the lender takes over the property, they could take over a property with a negative value in it because it has to be finished. And I would just had something still we're working on, but we were able to get rid of the property where it was it's just a real estate venture that did not work out. I was not involved in the earlier part of it, just the tax planning to try to get rid of it. But what happened was, and this was in actually Georgia, was the local jurisdiction was so mad that they had this half-finished real estate project that they started fining the owners $1,000 a day or something until it was done, because they had blown all their permits and everything else. And essentially there for the lender, again, the lender was looking at us because they didn't have very good guarantees, and they were afraid we were going to say, here's the key. Because if we just said, we're walking away, you foreclose, what would have happened is that lender would have taken over, had to finish that project, and paid those fees. So it's a very, very dangerous situation for a lender when there's when there's improvements being constructed or anything else. So oftentimes what you'll see is something called a completion guarantee that has to be signed. They want a person to be liable to make sure that when they fund a construction project, someone is personally liable to make sure that it's going to be done. And when I represent the guys in the completion guarantee, I say, well, sure, but are you going to advance the money for us? So let's say the entity runs out of money and we need more money to finish it. If I have a completion guarantee, are you saying I have to come out of my own pocket to fund these things? Those are the types of things that you need to negotiate. And when it's done, does my guarantee continue to go on forever? Is it truncated at some point? What is the level of that? These are all things that can be negotiated between the lenders and the borrowers, and that's something I would really, really encourage people to look at very, very closely when they're negotiating these things. And to loop back to something we talked about a little bit earlier. Sorry, I'm trying to keep it cogent, but when you have completion guarantees, when you have individuals who are guaranteeing things in the entity, that's something else we have to be very careful of, is what rights do they have to indemnity under the document. And when you're a member, you might say, well, look, I know I'm not personally liable. That's nice. I know that we might find personal liability against somebody else, but I want to make sure that I'm not paying the promoter or the contractor, whoever's supposed to, I got into the deal for, I'm not paying for their negligence, or I'm not paying because they didn't do a good job. And so all of this comes back to is that when you look at these things, I'd say early and often is really where you should try to get good legal help for them. Oftentimes when it's too far down the road, it's very difficult. And I'll wrap up quickly just with really quick story about what I talked about before the commercial mortgage-backed securities, that what happens, and these are loans that are billions and billions of dollars loans across the country with these, is that if there's a foreclosure, if the loan goes into default, they've all been sold into a giant pool. And you can't call your neighborhood banker anymore and say, hey, Bob, Sally, we've been doing business forever. I need to talk to you. There is no Bob and Sally within one. You're going to get a trustee in Kansas City who's being paid as little as possible to administer this giant pool of loans. And you're going to say, well, I've got a property in Beverly Hills or 1 Market Street, San Francisco. And they're going to say, oh, is that nice? And they're not going to deal with you on a business way. And what happens is then if it goes into foreclosure, it goes beyond that, then they have to have what they call the special servicer. And the special servicer is somebody who is hired by the bondholders to just basically make your life miserable. They're the only ones who have the ability to work out the loans. The banks don't have it anymore, the trustees don't have it anymore, only the special servicers, and they're very, very difficult to deal with. It's very, very difficult to deal with. And it's been something I've had an issue with, and I deal with them all the time. Luckily, I have a decent relationship with most of the counsel they use, so we're able to get around it that way. But they're not your friends. They're not going to look at it that way. And the reason I'm going into this so much is it's not as if when you sign the guarantee, they say, okay, you just signed the guarantee and you worked everything out. And, but if something goes to special servicer, they're going to say, in order to get out of it, you're going to have to pay the special servicer's fees. You're going to have to pay the special servicer's counsel's fees. You're going to have to pay their appraiser. You're going to have to pay their accountant. You're going to have to pay all the property manager. And so even when something doesn't go fully into foreclosure, you can find yourself liable on these guarantees. And another story, and I'll set up after this one, is a situation that happened, and I just want to caution everybody, when you sign a guarantee, or when you do real estate deals, you really are putting yourself, unless you control the entity yourself, unless you are the principal and you're going to make all the decisions, you are exposing, I think Harry said, and it really should make people think about these things, you're exposing your personal assets to things that might be completely out of your control and things that might be in your partner's or associate's control that you might not know them. You might not have done business with them before. You might, and if they're committing embezzlement, somebody who's committing embezzlement, that causes the property to go down, and you sign the wrong kind of guarantee without the right kind of protection, they're going to come after you. I had a situation where it was a bankruptcy, they came after all the other guys because the way they held the property was not my advice. But once a guarantee gets invoked, they're going to come after you, they're going to look at you, and at the very minimum, and I think Harry was really, very, very, I'm a transactional lawyer, which means I'm involved, my clients get involved with litigation. I don't run the court. I like to do deals, I like to add value to things, but I'm around the litigation enough, my clients get, I'm a lawyer, my clients get in the litigation enough that I've learned, and one of the litigators told me once, litigation is inherently unfair to the participants. It's even going to be more unfair if they're a big financial institution and you're an individual. And when they come after you in a guarantee, even if you're right, you got to hire a lawyer, you're going to be behind, you're going to stay up at night, stressing about it. It's a miserable, miserable experience. And what we want to do, our job, what Harry and I try to do with our clients, is we want to stay out ahead of that. We want to know that if these situations come up, if God forbid you're in that situation, we've protected your assets, we know what your exposure is, and that we look at the guarantee, we look at the documents you signed, and we can tell exactly what your liability is, and hopefully whoever helped you negotiate it really understood these issues and structured it in a way that was that protected you the best way you could, and even more so, that you understand it. And that's really what Harry and I try to do with our clients. That's why I think we get along so well, is we want to make sure that our clients, before they go into a transaction, before they expose themselves, they really know what they're getting into, because it's like crossing the highway. It only takes one time, right, for there to be a real catastrophic event, and it could wipe you out. And just because it hasn't happened yet doesn't mean it won't happen. And our job, and one of the reasons I think we really love what we do, is we help people stay out of those situations and add value to the transaction. So I hope I hope everybody got something out of this. I hope it was productive for everybody. As always, I learned from Harry. And if anyone has any questions, you'll have all of our information, and love to hear from you. Thank you very much.
All right, Glenn, let me just jump in there real quick. So this is Paul. Hey, I wanted to just get myself organized here. So wanted to thank everybody for showing up. We had a really, really great attendance, and thanks for hanging in there. We know everybody's busy. Couple takeaways is that if you're jumping into any sort of real estate transaction at all, it would behoove you to get a hold of Glenn and look for my follow-up email. I'm going to send you the contact information, the information about how to sign up for the complimentary assessment, whether it's on Glenn's side, you're dealing with a real estate transaction, on Harry's side with protecting the asset. And really, you should get both. And so look for that email. It'll come from me, Paul Hitchcock. And again, thanks for showing up, and look forward to seeing you again here on one of our webinars. Thank you.